First, I guess, tell us what exactly the case was in Milligan.
Yeah, the case was a challenge under the Voting Rights Act to the districts in Alabama. There are 7 districts in Alabama, 7 congressional districts. 27% of the population is Black, and there was a single Black majority district, when if you do the math, it should really be 2. So there was a challenge.
Out of 7. That's 1 out of 7.
Which I think 2 out of 7 ends up being 28%. So there are 27% Black voters. It makes sense that you'd expect 2 districts. So the challengers to the district bring a vote dilution case. And that gets analyzed under a framework from the 1980s. There's this case called Jingles, which has this whole sort of this really long process you work through to see whether there's been vote dilution. And going into it, I think the expectation was that John Roberts was going to lead the charge to either weaken that test or potentially find that Section 2, as it's currently interpreted, is unconstitutional because it requires in function the consideration of race. And so, I think most people were shocked when not only did he not find Section 2 unconstitutional, but he stuck with the test and sort of dutifully applied it and said that Alabama needs to create another majority Black district.
What makes Section 2 distinct in that way from the other parts of the Voting Rights Act, right? Because it's not as much about intent as, Roberts had argued in the past. It's about outcome.
That's right. So there were amendments to Section 2 in the early 80s that basically there's a Supreme Court case that said this is actually about intent. You have to prove discriminatory intent, which is, of course, very hard to do. Congress amends the law to say, no, you don't need to prove intent. You just need to show that it is discriminatory in practice. John Roberts was a lawyer working against those amendments, working to say that, on behalf of, I think, the Reagan administration, to say that the amendments should not pass. They did anyway. But that's why it's sort of unique, because it doesn't really matter in this case whether Alabama can prove that they were not trying to do anything racist. All that matters is the output.
What's also interesting to me, too, is that it's not like, it's one of the, just because Congress had amended the Voting Rights Act to be explicit in this instance is no protection, or at least it hasn't been in the past, for the Voting Rights Act. Right? Like we saw in Shelby, which was the case in 2013, where they were looking at preclearance, where the court between Scalia and et al. Basically said the only reason why Congress reauthorized the Voting Rights Act, I guess it would have been 5 years earlier, 6 years earlier, was because they're afraid of like being considered to be racist. And so we don't need to pay attention to that.
That's right. I think it was Scalia at oral argument said the fact that the reauthorization of preclearance had been something like 98-0 in the Senate. He said that actually works against it. It proves that it's sort of, not really truly being considered by Congress, which I always found a bit rich, considering I think he was appointed under about the same number, 96, 98-0.
Right.
The Roberts approach to the Voting Rights Act has really not shown a lot of rhyme or reason other than generalized opposition to the Voting Rights Act, which I think is why this caught people off guard. Shelby County has almost no constitutional undergirding at all. He just didn't seem to like the preclearance regime. So the fact that he would come out here and just sort of fully embrace what is undeniably a court-created test from the 80s that this court would almost certainly never create, it was jarring. Not everyone was shocked, but I was shocked. Yeah.
And we should say that the way that they basically killed the preclearance provision was they didn't actually say you can't have a preclearance provision. In other words, that states that had a history of racial discrimination had to get permission to change their voting laws from the DOJ. It's that how you choose which those states are needs to be updated in a way that Congress is just going to have to figure out. And basically, for all intents and purposes, threw it into oblivion. So they could have theoretically done the same thing with this case, right? Is say, we don't have a problem with a provision that says you got to change it if the outcome is diluted, but you just need to calculate that in a different way.
Right. They could have punted it to Congress in different ways. They could have simply demanded race neutrality, which is what Alabama was pushing for. Alabama was basically saying, we have all these ways to go about creating districts that are race neutral. And the counter to that was, well, hold on. The whole point of the Voting Rights Act is to very specifically protect the voting rights of Black people in particular, and in the South in particular. So going in with a race neutral approach doesn't really make a ton of sense here. This is something that Ketanji Brown Jackson brought up in oral argument very effectively. And Roberts has a history of embracing that sort of race neutrality as a constitutional principle. So I think that was a big fear. There was a fear that they could knock it back to Congress with the full knowledge that Congress wasn't actually going to do anything because Congress is in deadlock on every substantial issue. On the other hand, they could have just outright struck down Section 2, which you can essentially see that Clarence Thomas in his dissent would love to do.
So I'm going to ask you to go. There were two things that went on here. And one was that the first time these lines, these districts were challenged was back in 2020 in the run up to the 2022 election. And it made it to the Supreme Court. In the shadow docket, they basically said, no, we're not going to deal with this here. Kavanaugh voted the other way. Roberts voted to against punting it, but only because he didn't think it should be on the shadow docket.
Right.
What do you think happened between then, aside from the Alabama probably having one, more Republican seat than they would have, and maybe also Georgia? And I mean, let's put that aside because I want to ask you about that. But what do you think happened? Because also, and you mentioned KBJ's discussion about the intent of the Reconstructionist amendments being specifically not race neutral, which is probably something that's never been articulated by any, because we are living in a different era of understanding of those amendments too. What do you think happened? I mean, I know this is complete speculation, but this is your job.
I love to speculate. I think that the most likely thing is that Roberts was feeling the heat institutionally, and he is an institutionalist, and he decided to moderate his vote on this issue, especially knowing that that Kavanaugh was going to come along. If you look at the first, I mean, it doesn't make much sense. If this comes to the Supreme Court on the shadow docket, Roberts joins with the liberals, ostensibly on shadow docket grounds. Kavanaugh is apparently fully okay with the potentially unconstitutional map being used in a full election cycle, and then switches the next year. The only thing I can think of that truly makes sense is that Roberts felt the heat and brought Kavanaugh along. I also think that Kavanaugh is enigmatic in a way. He really does have sort of odd beliefs about this stuff, and there are principles that were theoretically at play in 2021 when it first came to the court that aren't at play anymore. But I think that the prevailing theory that this was a case that would not have come out this way if you didn't have Dobbs, if you didn't have like the Clarence Thomas drama. I really think that Roberts goes the other way and is just trying to let a little bit of heat out of the whole thing. That's my best guess.
And you know that Kavanaugh likes beer.
That's right.
Okay.
We all know that.
Let me ask you one more question about that, and then we'll move on. How much do you think? Do you have any sense of where, not just the way that Dobbs was decided and the heat that came from that, and not just like, all the sort of, there's a tremendous amount of, I think, scrutiny on the court in terms of its ethics, which is, way overdue, and there's, rumblings of some type of reform in that manner, which, for a guy like Roberts would make him look bad, I think. Do you think that there's also anything going on with the leak of Dobbs? Because the idea that the court couldn't find out who did it, Alito subsequently saying, like, I know who did it after that, which I have no doubt, frankly, that he knows who did it, because I've been convinced from day one that it's someone he's associated with.
He said that looking in the mirror.
We know that, he did something to this effect back in at least two other instances. The Hobby Lobby, we know that he leaked. And we know in 2012 that he was complaining about Roberts in the ACA case to the Washington Post. Do you think that there is internally something going on with that? Because I'm also thinking about the case now escapes me, but where KBJ was the lone dissent, and Coney Barrett wrote the decision. This was just the other day. I can't even remember what the case was.
Yeah.
The 8-1.
Oh, Glacier. Yeah, Glacier Northwest.
Glacier Northwest,
Do you think that this is playing, like, there's any dynamic here where the idea of, like, Roberts, corralling Kavanaugh, and maybe, Sotomayor and Kagan working on Barrett, like, they're like, how much of this is just sort of fever dreams in my head?
Probably most of it, but I think that there is there's a degree to which, in the general sense, you're probably right. It's hard to be right in the specifics, but I think that it seems as though Roberts is wrestling a bit for institutional control behind the scenes. Part of this case, and I think maybe an underrated part of this case to non-lawyers especially, is that Alabama's lawyers were terrible and were really swinging for the fences and sort of bringing some extreme arguments as their primary arguments and sort of targeting the right wing of the court very directly. It's possible that someone like Roberts sees that as a challenge to his own control over the court, and it pushes him away from those arguments. I think that this all sort of plays together in Roberts' mind, if I had to guess. I don't know what the details are, and we might never know, but it feels to me like it's unquestionable that Roberts wants to have control over the institution and feels in certain regards like he's losing it.
Is that because Alito and Thomas are essentially like becoming these two very emboldened players within the court? And my sense too is that maybe Kavanaugh and Roberts find some like connections as a little bit more pragmatic. I know I'm restating some of the stuff we already said, but that's just that's what I see from the outside. It's just so hard to say.
I think that's right, and I think that they had some big wins. The right wing of the court, the far right wing of the court, we should say, had some big wins over the past couple of years, Dobbs in particular. And I think that emboldened right-wing lawyers across the country to bring cases more aggressively. And so not only do you have the right wing with Alito, Thomas, and sometimes Gorsuch exercising a good amount of control, but people are pitching to them. Arguments are being designed to their sensibilities. It all. I think if you're someone like Roberts, it all starts to irritate you. Is my best guess. And in some cases, it might work because Roberts does have some pretty aggressive right-wing beliefs in many regards. But after a while, my guess is it's wearing on him. He might not feel particularly strongly about the gap between the center right and the far right on a particular issue in a way that Clarence Thomas might.